Ladies and gentlemen, welcome to another very special episode of Candid with RMT, and today I have with me one of the most sought after, respected, reputed criminal defense lawyers of our country, Mr. Tanveer Ahmed Mir. Hi sir, welcome to Candid with RMT.
Thank you very much for having me. It's a pleasure.
Right sir. This is a question I often ask the seniors of our profession, sir. When they reflect back in their journey from law school into practice to who they are today, sir, what are those sort of takeaways or those moments that you want to reflect back on and actually give out as a message to our audience and tell them of what to do and what not to do, sir?
Well, as far as my memory throws me back, I feel that the mentoring in the Campus Law Center at Delhi University by some exceptional faculty members was a very strong impetus in framing our mindsets insofar as what you are supposed to do tomorrow when you start practicing as lawyers. So the classroom discussions, the chamber discussions, sometimes discussions over dinners with world-renowned professors like Dr. MC Sharma, one of the best-known jurists in India, Professor K Singh, Professor B.D. Pandey, Dr. Alka Chawla, and many others respectively. The wonderful interactions with them in classroom, beyond classrooms, on interactions with lunches and dinners, sometimes at their residences, sometimes in my hostel where I used to stay, had a very huge impact personally on me as to how I have to work as a lawyer. But if I say it in brief terms, what I learned from them is number one, to develop a very strong sense of fearlessness. As a core legal professional must be like a fearless lion in a court of law, because you are being conferred a solemn duty of defending people. The second theory is that once you decide to defend somebody, you cannot and ought not take a step back, and you have to work diligently and within the system and try and do your best to the brief. And that's how things work. So diligence, honesty, and a very, very strong fearless attitude, and an insight, a soul conviction, if you can, if I can use that term, are some of the background insights that had a very strong impact with our faculty. Because ultimately, for a lawyer, there are two things that shape his career. One is the mentoring that he receives in the university where he studies, and one is the mentoring that he receives from his seniors, his own mentors, his own law offices that he works with, and the environment of the courts where you work, in terms of how you are to then conduct yourself and as a legal professional and in your legal career.
Right, sir. Talking more about your university days, sir, this is probably one of the most highlighted cases of back in the day, sir, where you have been a witness to the Priyadarshini Mattoo's case.
Yes.
And you were still an LLM student back then, sir.
Yes.
How was that whole experience, sir? And did that experience actually shape you into taking up criminal defense, or was it something that was a pure coincidence?
No, I had from second year LLB onwards, since I used to live myself in the International Students' House on the Mall Road in North Campus, Delhi University. From second year LLB onwards, I think, sans my examination periods, at least twice, thrice, or sometimes 4 times a week, after about from 2 o'clock to around 4:30, I used to go to district courts at Pisazari.
Wow, sir.
And usually sit in the courtrooms and watch some extremely interesting and deadly duels between defense lawyers and prosecutors in serious crime courts, which were virtually the courts of additional sessions judges. So I do recollect between 94, 95 and 96, including 97, when I went into my first year LLM, that in the district courts at Pisazari those days, we did not have a district court in Rohini, we did not have a court in Dwarka, we did not have a court in Sake. So Pisazari was a very big hustle and bustle place, a lot of people all around. And the additional sessions judges were very busy recording evidence. So virtually on one end, say in a case of murder, the honorable judge was supervising the evidence, and on the other side the prosecutor was supervising the evidence, examination, cross-examination. And that, as a law student in second year or third year, used to be extremely inspiring, intriguing and inspirational. So sometimes the judges, since I used to be myself in black and white, the judges would say at some time that, yes, Vakil Sahab, in which case are you represented? So I would say that, Your Honor, I am only a law student and I come to the court to watch the proceedings. Sometimes the judges would say that, yes, then you please step forward and assist the prosecutor. Just as now internships, happen. In those days, there was not much a concept of internships. But I had a very wonderful interning experience in serious crime courts in Pisazari, which sort of infused a very early idea in my school of thought that being a criminal defense lawyer in the legal field, especially as a strong trial lawyer, is something which is hugely interesting, because you get to build up a case right from the beginning and then take it up as and when the matters get escalated to higher courts, appellate courts, revisionary courts. So besides that, the unfortunate rape and murder of my friend in 1996, that is late Priyadarshini Mattoo, was a very moving incident, because we hailed from the same state, and although she was a Kashmiri migrant from Pandit community, and the day unfortunately my friend got murdered, we had lunch together, which was seriously frightening for me to next day read in the newspaper that such a horrible and hellish incident took place. Then after a week, this matter got transferred from Delhi police to CBI. And I do recollect that the investigating officer of the CBI, Mr. Inspector Ashok Kumar Karyal, did land up in my hostel and had a conversation with me for 2 straight days over long periods of time. And I assisted and helped him in understanding in terms of what all was happening and how the accused used to constantly harass my friend as some kind of an obsessive person. I cannot use the word lover because that would be insult to love in itself. So after those conversations, next year in 1997, somewhere in August, I got a summons from the Court of Additional Sessions Judge at Patiala House Court to testify as a witness. And Santosh had a very strong defense because he had engaged one of the Delhi's most foremost criminal trial lawyers in a gentleman called Pandit R.K. Naseem Sahab, the gentleman who defended the Jessica Lal case. He was one of the most formidable criminal lawyers at that time. CBI was being represented by a special prosecutor called as Mr. R.K. Kalra. And after I got the summons, there were a lot of people, wanting to visit me and have a talk with me, and mostly wanted to impress upon me that better don't testify, lest you will face some harm. So one thing led to another, and on one occasion when things got very bad, so I took a piece of a paper or a slip which I found under my door to my IU in the CGO complex. Unfortunately, my IU was of no help to me. So the witness protection regime was as bad as then as it is today, and there's nothing for witnesses. And finally, I mustered up the courage, and in September I went to testify. The testimony, I testified as prosecution witness number 10, and by the grace of God, the only person from DU who testified for prosecution was me. So although CBI did talk to a lot of other personnel and people as well, but with due respect, none of them mustered any courage to come forward and testify for a classmate or a friend or otherwise. So my testimony later I found, because I was the only person to prove a motive in terms of what used to happen with the lady and how she was getting harassed. As the fate would have it, the accused got acquitted from trial court, and then an appeal was lodged. In the appeal, the acquittal was set aside, and Justice R.S. Sobi and Honorable Mr. Justice P.K. Basil reversed that acquittal and gave a death penalty to the accused. An appeal was taken up to Supreme Court, but death got converted to life. The Appellate Court judgment relies on my testimony on a number of occasions insofar as proving a motive is taken into consideration. So, testifying for my friend gave a very different perspective to my own life, insofar as mustering up the courage to testify amongst very serious threats, pressures and coercion coming from many quarters. And that certainly, helped me in killing my inner fear that, if I can have the courage of going to a court, and testifying in a very horrible murder amongst virtually death threats, so then, lawyering should not be so difficult. So that's one perspective in the faculty itself when I was doing my law course that had a very, very huge impact in my personal approach to my own career or the way I look at my things.
Right, sir. So, talking more about, starting lawyering as a law student.
Yes.
And then gradually getting a kickstart, I would say,
Yes.
in your career of taking something as, challenging as criminal defense.
Yes.
Talk us more about your briefs and the most challenging briefs. You have a wide plethora of cases which I have in front of me, but I would like to hear it from you, sir. Your 3 most challenging briefs.
Well, I guess, I've had the opportunity of defending the accused in the famous 2D spectrum scam, or defending Dr. Rajesh Talwar and Dr. Nupur Talwar in the famous Arushi Talwar in Raj W murders, and setting up the trial for them, cross-examining most of the witnesses, and then arguing the appeal in the Honorable Allahabad High Court, leading to a comprehensive exoneration. But I feel that one of the most challenging briefs that I personally argued was a triple murder where accused had committed a dacoity on a Ford car showroom in Okhla and shot dead 4 security guards. 1 lived, 3 died. So 4 persons were put to a trial, and they finally got 3 counts of life and 1 count of 10 years. That's a case by the name of Kaliram versus State. I happened to argue the appeal before the division bench led by Honorable Mr. Justice Pradeep Nandaraju Saab, as his lordships then were. And I thought that arguing that appeal, particularly in an indictment and a successful indictment for 3 counts of murder and 1 count of 10 years, was very difficult for a defense lawyer to plead for a full acquittal. But I did not do that trial. I happened to argue the appeal. The trial lawyers had done a good job, and the appeal was argued for about 7 to 8 days, and it resulted in an acquittal of all 4 accused. So perceptibly, this may be the only triple murder acquittal ever done by High Court of Delhi, as far as my information is taken into consideration. This was a very huge challenge. Setting up cross-examination and examining and cross-examining witnesses in Arushi Talwar in the Ghaziabad court, where my clients, on account of the whole media picture of the double murder and a very strong and hostile opponent of CBI prosecutors, was again a very challenging proposition, because every day everything was getting reported and millions of people had their own opinions. So it was a very stressful experience. More so at that time in 1213, I was doing both the Arushi Talwar Raj double murders and also the 2G spectrum, whereas there was only one prosecutor in 2G. In Arushi Talwar, CBI had put 3 prosecutors, and conducting that defense was extremely stressful. So I think that matter also has great significance, because it led to a double murder conviction. And then in January 14, I drew an appeal myself, lodged it in Allahabad. And somewhere in 16-17, precisely from 22nd of September 16, we happened to argue that matter, as a lead counsel myself, along with a fellow lawyer from Allahabad and my other colleagues. And we argued, I remembered personally arguing that matter for 30 continuous days, in trying to prove to a division bench in Allahabad that both my clients were actually innocent from any corner that your lordships want to see, any piece of evidence, any witness, any document. And getting that full exoneration with very strong strictures against the CBI and the trial judge was a very humbling experience. Though the matters are now sub judice in Supreme Court, so the last word is yet to be said. But doing that trial was a huge challenge, because unless and until I did not do a quality defense work in setting up the cross-examinations, by no stretch of imagination could I have secured the acquittals and comprehensive exonerations for both of my clients. But the doing Rahim murder for a 16-year-old for about 2 years, for the next slit of a 7-year-old in Gurgaon district courts, was also very challenging. Then defending Gurmeet Rahim in Panchkula and Chandigarh was again a very challenging brief, insofar as the office bearers of Dera Sacha Sauda, after the violence and the carnage that took place in July 17 in Panchkula, where more than 38 people got shot dead. So Gurmeet Rahim at that time was at the receiving end, and probably was the most hated person. He was facing very strong offences, including but not limited to waging war against the country and the government. So we happen to argue that matter in Punjab and Haryana High Court on various motions. And finally, we got a comprehensive discharge, leading to bail for almost all the accused. So top 3 cases have to be a brief like Kaliram, a brief like Arushi Talwar, perceptibly a 2G spectrum in a different perspective, but Gurmeet Rahim is also up the ladder. And there have been some other cases also which were very frighteningly tough insofar as hard, difficult briefs, including defending an RJD minister in Nalanda District Court for a sexual felony, where I conducted a cross-examination and put in the final arguments. These have to be the top-line cases, in serious felonies. Though now we do more money laundering and we're defending cases like the Delhi excise scam. These are also very big time challenges in its own time. So Kaliram, Arushi Talwar and Gurmeet Rahim should, in my understanding, rank very high. But insofar as, yes, the challenging briefs are taken into consideration, where at the end of the day, whether you win or you lose, but you feel very satisfied in terms of the quality of work that you put in as a defense lawyer.
Absolutely, sir. Coming more to the point you mentioned about taking part in the cross-examination of fellow gentleman who was accused before the district courts. Now, I want to understand, sir, from your perspective. Let's say you are in a trial court, and the trial court lawyer, let's say, does not do his or her best in order for you to get that brief when you get that appeal in the High Court.
Correct.
So, is your involvement also there at the time of the trial, or is it something that you involve yourself in only after the verdict of the district or the sessions court in the, let's say, appellate forum?
Actually,
or is it a mix of both, sir?
Well, most of my cases have been where I have conducted the trial myself.
Right, sir.
For example, 2G Spectrum or Arushi Talwar or Brian Murder or Raj Vallabh Prasad Yadav. But if I am to, for example, also defending Kuldeep Singh Sengar in the Unnao raid case, where an appeal is pending before a division bench of Delhi High Court. So if I do get engaged at the stage of trial itself, then there is a very good opportunity for me, as well as the challenge, to set up a very good trial, to do a very good quality, strong quality cross-examination. Because ultimately, in any piece of litigation, whether it is civil law or criminal law, if you win the case on evidence and on trial, then certainly you will win either the case in the trial court or in the appeal. But if you lose on evidence, for example, a case like the trial of Prakash Chala in the teachers' scam case of Haryana. Now, there in the trial, my understanding is, with due respect to everybody who was there, of course, everybody would have done his best. But since the witnesses kind of overwhelmed the defense lawyers, or the cross-examinations could not come up to the mark, therefore, in appeal, even if the best lawyers came, for example, in Prakash Chautala's case, the appeal was argued by nobody, as big as the legendary Ram Jethmalani. So, what bigger lawyer could a Chautala get to argue his appeal? In comparison to legendary Ram Jethmalani. But even Ram Jethmalani could not, successfully win that case, because the trial was lost. Now, in comparison, if I did a strong quality trial in Arushi Talwar, Hemraj double murders, that is what helped my clients in the Appellate Court to get a comprehensive exoneration.
Right.
So it's I relish the opportunities to go to trial court because my core practice and domain specialization is in criminal trials, cross-examinations, arguments, strategy. And if I get an opportunity to do that, for example, recently in the cold block scam cases, the first comprehensive acquittal that has been done by the cold scam designated court at Rouse Avenue Courts is a matter where I led the cross-examination with my associate lawyers and lawyers from Cyril Amarchand Mangaldas for an American company. Now, if we did not do a good quality trial, we could not have got our clients acquitted.
Yes.
So it's always beneficial to start up in the trial, but after all, you're not going to conduct each and every trial.
Yes, sir.
So even if a trial has been conducted as a strong domain specialist, you have to have those hawkeyes, in the appeal, so as to convince an appellate court that there is a case for an acquittal still there.
Right.
That is equally challenging.
I'm sure, sir.
So the challenges are to be relished.
Yes.
And that's how you walk the talk. So you're not going to do every trial. So you should be ready and willing to take a dead brief as well.
Absolutely, sir.
Yes.
Absolutely. And for all those young upcoming lawyers watching this, this advice should be taken into with very serious, I would say, notion, because if you're not taking up a dead brief, then you're actually shying away from that challenge that lies ahead of you.
Absolutely.
So please, by all means, take up any and all briefs that you get your way without a slight pinch of shyness, because that is what will prepare you when you go ahead in the profession. Talking more about the part of cross-examination, so
yes.
that is something that
yes.
you actually enjoy as a criminal defense attorney. So
yes.
Having Mr. Jatin Singh on my podcast,
yes.
He mentioned a very important aspect of cross-examination, whereby he said, in the cross-examination, it is not what you ask, it is what you don't ask.
That's correct.
That is what makes it effective, efficient cross-examination.
Yes, it all depends upon what is the evidence that is set up by the prosecution.
Yes, sir.
And how you are to handle those testimonies and those examination in chiefs of witnesses.
Right.
So obviously, any court criminal lawyer or a court civil lawyer, he has to be a very strong and deft trial lawyer to begin with. Because if you don't practice trial law, so you can never be a strong litigator ever in your life. And people who tend to practice directly in Supreme Court or High Court and do not have an exposure of trials, always have somewhere a weaker heart. Somewhere they feel that their advice is half-baked, and surely they cannot certainly do the kind of a job which a specialist trial lawyer will do. So it's very important for any litigator who's beginning his career to spend some quality time in trial courts,
yes, sir,
with good trial lawyers and get an exposure of how to set up a cross-examination. Well, that requires a bit of a training, a bit of an exposure. First of all, your own willingness to take the plunge and to be ready to grasp the entire narratives. And well, if the cases are, for example, bodily offences like murders or attempted murders, then it's very important for the lawyers also to see the spot, where these felonies have been committed. I recollect visiting the apartment L32 in Jalvayu, Bihar, when I took up the trial in August and September 2012, at least a dozen times, make my own notes, take my own photographers, and take every measurement and see everything, and then collate it and juxtapose it with the prosecution case. So each witness is to be prepared individually. So if you start one witness, don't think about the 10th witness, lest you get your mind will get obfuscated. So it's like a batsman who has to score, say for example, 250 runs in 20 overs of a match. So you go ball by ball, over by over, don't get by the challenge of the total. So each witness must be prepared. So there are techniques to do a quality cross-examination. And it's a very generalized proposition that it's not about what you ask and what you don't ask. But there are cardinal principles of setting up a cross. For example, you have to first understand how to demolish a witness. So methodologies of demolishing a witness lay in introducing strong, fatal contradictions with prior statements, then doing a very strong merit cross in order to demolish the credibility. Also infuse a counter defense and then have your own chapter of suggestions. And whilst you're doing that, you have to be mindful of who is to be cross-examined to what extent. So if it's an eyewitness account holder, then you have to see what is the account that he is stating and how tomorrow, on the strength of your cross-examination, you are going to argue at the time of submissions that why this witness should be disbelieved by the court. Right. So ultimately, in litigations, there are two kinds of challenges that a defense lawyer faces. One is a case where overwhelmingly the prosecution charge relies on oral count of testimonies, and one is a case where there are oral counts of testimonies, means oral evidences and documentary evidences. Documentary evidences have a different approach and oral evidences have a different approach. So therefore, a trial lawyer must be deft in understanding how to take on an oral witness who's giving an oral account of facts in terms of having seen something, having heard something, having perceived something, being an eyewitness account holder to the incident or to activity post the incident, prior to incident. This all takes time, but where there is a will, there is a way.
Well said.
And there is a process to grey your hair in the court.
Yes, sir.
Correct. So this is not something like instant noodle mechanism. So lawyers, they progress with age, with more kind of work that they do. So the best thing that can happen to any lawyer is that in his early career, he gets very, very difficult briefs to do. For example, I in my earlier career did a lot of POTA trials. Now, POTA trials were very difficult trials. Why? Because even confession before a higher court was admissible. And there were usually recoveries of firearms, including but not limited to AK-47 rifles, whether planted or not. Now, cross-examining the witnesses from police officials of special cell. In a time, there were a lot of, if you remember that Ansal Plaza fake encounter, or I did a case called Humayun Tomb shootout case. Fending for POTA accused was very difficult, and we were again before a very difficult judge. And defending those clients, imparted very strong training mechanisms insofar as how to take on the witnesses. So any criminal defense lawyer, therefore, has to necessarily do a very sound training in the trial courts and be ready to take a plunge in very difficult cases right at the beginning. And then ultimately the criminal trials are not based on arguments for for example, issues like right of privacy. These issues don't these are issues, the constitutional challenges are very rare.
Absolutely.
Here it is whether your client murdered or not.
Yes, sir.
So that will not be decided on some Supreme Court decision.
Right, sir.
Also, the best of the trial lawyers or the best of the advocates as they grow, the best of the judges as they progress in judiciary or join judiciary at their careers are those kinds of lawyers or judges who rely upon precedents the least. So ultimately, in a criminal felony or even in a civil suit or otherwise, you have to decide a case on evidence and evidence alone. You cannot convict or acquit somebody by writing 50 Supreme Court judgments and 70 High Court judgments.
Yes, sir.
So therefore, a good trial lawyer, even if he walks into judiciary tomorrow, I'm reminded of a judgment written by then Honorable Justice Ashutosh Kumar Sahab, who came from Patna High Court to Delhi and then went back. He happened to decide a very controversial case of a filmmaker called Mahmood Farooqi in a sexual felony pertaining to a law intern who had come from Columbia University. Man was acquitted by a trial judge out of Saket District Courts and acquitted by Justice Ashutosh Kumar. If you see that judgment, in that judgment, whilst acquitting the accused, there is not even one precedent ever written or discussed. Similarly, in Arushi Talwar Hemraj double murders, the trial court verdict was beset with the trial judge writing at least about 200 Supreme Court judgments. But the Appellate Court, I think, while it's writing a judgment of more than 100 pages, discussed evidence and evidence alone, and wrote only one judgment, relied upon only one precedent, that is a 5 judges bench called Tehsildar, insofar as how a contradiction is to be interpreted. So, good trial lawyers, good judges emanating from the bar or from the judiciary itself. My perspective in lawyering is that you cannot have a system of overwhelming reliance on precedential law because the precedents just don't work. You have to concentrate on evidence and evidence alone.
Right, sir. Right, sir. Talking about the judiciary and how the judges sort of interpret the judgments and the evidence. You, sir, have been offered judgeship on 3 occasions. Talk us about the relationship between the bar and the bench, sir, and how the two processes of appointing judges and the collegium, and is that the way that should, your 2 cents on the appointment of judges, sir, first of all, and then talk us about your journey, sir. Why didn't you not choose accept the judgeship, and should more lawyers be offered judgeship in order for the judiciary to at least be at full capacity, because we are lacking on account of judges, which is why there is so much of pendency of cases. How do we as a fraternity tackle this issue, sir?
Well, that's multiple questions, but nevertheless. So first, let me take a call on why I did not, give consent for an offer of judgeship in J&K High Court on 3 separate occasions. Very simply, I thought that personally, first of all, I would express gratitude to the honorable judges for finding me fit enough to take up the mantle. But personally, I decided that the lawyer that I am, or the approach that I have in my life, I would be best suited to continue the work that I am doing, insofar as having the freedom and ability to represent a variety of people before a court of law. So on one hand, whereas I defend people like Shivinder Mohan Singh in the alleged money laundering scam or the fiscal scam of around 3,000 crores. I also get to defend people like Sharjeel Imam, who is a flagship case of resurgence for sedition law in India. So this is a personal call that every person has to see, take on his own. So I would say that the inner voice that I got is that that I'm best suited to work that I'm doing. So I respectfully declined the offer, and I'm sure that amongst the legal fraternity there are people who are doing wonderful jobs in judiciary. The appointment of judges is something a debate which is never ending. But constitutionally speaking, that yes, the very concept of having an independent judiciary lay in the call for application of checks and balances and freedom of executive coercion pressure on the judges, insofar as the executive always has its own vested interests, political interests, and that's how a constitutional democracy works, where you have to have a robust and strong independent judiciary once you are a judge. That's why you cannot be removed except by a 2/3 vote in the parliament. The appointment process cannot be 100% flawless. There are always questions, but I believe that the people or the judges who are appointing judges from the bar, overwhelmingly, the people who get appointed are people who mostly are in some kind of very strong government lawyering, and you have to take a very strong call that when you appoint judges from the bar, because when you appoint it from the district judiciary, the route is different, seniority and a particular quota in every court. But when you appoint judges from the bar, my personal opinion is that you should appoint judges who have a very strong trial exposure, correct, and then have an appellate exposure itself. If you are going to appoint only people who have all their life, appeared for Central Government of India or for Delhi Development Authority, then somewhere they themselves will be very lacking, in the ability to perform the job tomorrow, and it's a very challenging job. Not that you also learn when you are on the bench. So there is a scope for improvement, but I am a very strong believer that appointment of judges should be kept always away from the dispensation in power and the executive, because the constitutional ethos of then having an independent judiciary will get very strongly compromised. If you start appointing judges on the basis of the taste and the trust of people who are in power here, there or anywhere else, then how will you tomorrow have systematic checks and balances, which only an independent judicial system can do?
Right, sir. Right, sir. A final question, sir, before we wrap this up. This wonderful portrait, sir, we have behind is, I believe, has a backstory.
Yes.
For our audience, if you could.
So this is the iconic Court 42 in the Allahabad High Court, where the Arushi Talwar Hemraj double murders was argued. This side, Tanveer Sahab and my colleagues were arguing. This side, the CBI senior advocates and other counsels were arguing. So this is a British time court in Allahabad with a lot of beautiful woodwork which has been captured on oil on canvas. So a very good memory. So I decided to show it to a painter friend of mine, and he made this put up in the wall.
That's just beautiful, sir. With that, ladies and gentlemen, we come to the end of this podcast. It's been an absolute pleasure, sir. Thank you so much
Thank you
for being on Candid with RLT, sir.
Thank you.
Until next time.